Section 8. Additional Water Considerations. Water in Arizona. Connecting water maps to real-world water issues. In the last two sections, we focused on water maps and how they help real estate professionals begin the due diligence process. We looked at assured water supply maps, well maps, community water systems, groundwater rights, water banking, and water rights claim tools. Now we move from where do we find the information to what issues should we be watching for. This section focuses on additional water considerations that can affect Arizona real estate transactions, especially when dealing with rural land, agricultural property, development projects, private wells, or properties located in regulated water areas. Water in Arizona is not just about whether a faucet turns on. It may involve historic rights, priority rules, development approvals, future law changes, and how water certificates are managed. For agents, the goal is not to become a water attorney. The goal is to recognize when water issues may affect value, use, development, or risk, and then guide clients toward the right resources. Grandfathered water rights. One of the most important water concepts in Arizona is grandfathered water rights. Grandfathered water rights generally refer to water rights that existed before Arizona adopted modern groundwater regulations, especially before the Groundwater Management Act of 1980. These rights are protected under state law and are usually connected to historic water use. In simple terms, if water was legally used on a property before modern restrictions were created, that historic use may still have legal protection. There are two major types: Type 1 rights, usually connected to irrigation use; Type 2 rights, usually connected to non-irrigation uses such as mining, municipal, or industrial use. For real estate professionals, this matters because grandfathered rights can add significant value to certain properties, especially agricultural or development-related land. However, these rights are not something an agent should casually interpret. They require documentation, registration, and compliance. Preserving grandfathered rights. Grandfathered water rights must be properly documented and maintained. A property owner may need historical records showing how water was used. These records could include irrigation logs, old water bills, maps, photographs, or other evidence of historic use. The rights may also need to be registered with the Arizona Department of Water Resources, commonly known as ADWR. Here is a practical example. A farmer in Yuma has used river water for irrigation since the 1950s. If that farmer sells the land, the buyer may want to know whether those historic water rights transfer with the property and whether the rights remain valid. That answer may depend on historical use, documentation ADWR records, whether the water use continued properly, whether the use changed over time. This is why agents should encourage buyers to investigate water rights early in the transaction. Water priority, first in time, first in right. Arizona water law often follows the principle of first in time, first in right. This means older water rights generally have priority over newer water rights. During times of shortage, senior rights may be served before junior rights. Think of it like standing in line. The person who got in line first may have priority over the person who arrived later. In a water shortage, this can become extremely important. For example, a farmer with water rights dating back to the early 1900s may have a stronger claim than a developer who recently applied for water rights for a new project. If water becomes limited, the junior user may face restrictions before the senior user. For real estate professionals, this priority system can affect agricultural property value, development feasibility, buyer expectations, water availability during shortages, long-term land planning. Agents should avoid telling clients that all water rights are equal. They are not. ADWR and water regulation. The Arizona Department of Water Resources plays a major role in regulating and managing water rights throughout the state. ADWR helps oversee water rights, groundwater management, active management areas, assured water supply requirements, well records, and related water planning issues. This connects directly back to earlier sections where we discussed AMAs, AWS, groundwater maps, well registry tools, water use rights. When water questions arise, ADWR is often one of the first resources agents should direct clients toward. Changes to Assured Water Supply Law. Arizona's Assured Water Supply Program is designed to ensure that certain new developments have a reliable and sustainable water supply. As we discussed earlier, this is especially important in active management areas where groundwater depletion is a concern. One newer concept is the Alternative Path to Designation of Assured Water Supply, commonly called ADAWS. This provides an alternative method for developers to prove that a project has a reliable water supply. ADAWS may allow developers to use innovative solutions such as advanced conservation methods, reclaimed water stormwater, harvesting, water-efficient infrastructure, alternative water sources. This matters because Arizona is growing and developers are looking for ways to meet water requirements while adapting to changing regulations and supply challenges. For agents, this means water laws and development rules are not frozen in time. They continue to evolve. Real-world ADAWS example. Imagine a developer planning a new community in Maricopa County. Instead of relying only on groundwater, the developer proposes smart irrigation systems, low-flow fixtures, reclaimed water for landscaping, strong conservation planning. If the proposal meets regulatory requirements, ADAWS may provide a pathway to demonstrate long-term water reliability. For real estate professionals, this is important because future development may depend not only on water quantity, but also on how creatively and responsibly water is managed. Commingling of water certificates. Another advanced water issue is the commingling of water certificates. Commingling means combining water certificates or water rights from different sources into one system or pool. These sources may include groundwater, surface water, or reclaimed water. This can become especially complex in areas like the Phoenix and Pinal active management areas. A developer may need to combine multiple water sources to meet a project's water supply needs. However, combining water certificates requires careful documentation, regulatory review, and ADWR oversight. This matters because improper handling of water certificates could create delays, disputes, or compliance issues. Why this matters in real estate. A buyer purchasing a standard home in a city subdivision may never need to understand every detail of water certificate commingling. But developers, investors, land buyers, and agricultural property owners may absolutely need to understand it. For example, a developer purchasing land in the Phoenix AMA may discover that the project depends on multiple water sources. Before moving forward, the developer must confirm whether those sources can legally be combined and whether ADWR approval is required. This can affect project timelines, development costs, financing entitlements, marketability, risk. Agents working with land or development clients should be especially careful and recommend professional review. The agent's practical role. Arizona water issues can become technical very quickly. That is why the agent's role is to identify potential concerns, not provide legal conclusions. A strong Arizona real estate professional should ask, are there grandfathered water rights? Are those rights documented and registered? Is the water use consistent with historic use? Are there senior or junior water rights involved? Is the property affected by AWS or ADAWS rules? Are multiple water certificates being combined? Should the buyer consult ADWR, a water attorney, engineer, or title professional? These questions help protect the client and reduce transaction risk. The practical takeaway. In Arizona real estate, water is not just a utility issue. It can be a legal issue, a development issue, a value issue, and a long-term ownership issue. Grandfathered water rights may add value, but only if properly preserved. Water priority can determine who receives water during shortages. ADOWS may shape future development approvals. Commingling water certificates may affect large projects and regulatory compliance. The best agents do not guess. They ask better questions, use reliable resources, and recommend expert guidance when needed. That is how Arizona real estate professionals meet today's standard when dealing with water. Online discussion. Question. 1. Why can grandfathered water rights be important in Arizona real estate? Answer. Grandfathered water rights may add value to a property because they are connected to historic water use and may allow continued water use under certain legal conditions. Question 2. What does first in time, first in right mean? Answer. It means older water rights generally have priority over newer water rights, especially during times of shortage. Question 3. Why should agents be cautious when discussing ADWS or commingling water certificates? Answer. These issues involve technical water regulations, documentation, and ADWR review. Agents should avoid legal conclusions and recommend qualified professionals.